this evening could go in all sorts of different directions. My plan at the moment is I want to finish off last week because we didn't actually talk about toll and Alphapharm, and I think this is the case that brings together a lot of the concepts that were really important last week. So last week we were talking about where do you find the terms of a contract? In the conversation, in the documents, in the compilation of the two if we've got something that is a bit of both. And then also what happens when express terms of a contract are on something that isn't necessarily a contract document, like the back of an invoice or a ticket or a sign at a gate or something like that. And so I thought it was probably worthwhile actually spending a little bit of time talking about toll and Alphapharm, particularly because we've spoken about similar cases a number of times, but I think it brings the whole thing together. So I'm going to do that first. Then I'm going to move into the next topic. So we're going to talk about implied terms. Now, the reality is I will not have time to get all the way through implied terms today if I'm going to do it as a lecture. There were desk lectures for it, and I'm just sensing around the room and knowing where we're at in assignments that there is probably less than ideal viewership of those for this task. But that doesn't mean that you can't still do it. You know, you've got the rest of the week to have a look at those, and there are no desk lectures for next week because I haven't prepared any actually, but also because I need to pull all of these topics together when we start talking particularly about disclaimers and exclusion clauses. Now, as soon as I say that, you're already thinking, well, we've been talking about disclaimer and exclusion clauses all the time, and you're absolutely right. The reason we keep coming back to disclaimers and exclusion clauses in particular, is because usually that is the crux of an argument. Is this exclusion clause, in other words, the clause that says that somebody is excluded from liability or is protected in some way, is that clause part of the agreement? That's essentially the question we kept asking ourselves and that the courts kept asking in each of the cases that we looked at last week. So we're really going to pull these two topics together by using exclusion clauses, disclaimers, as or limiting terms, I think is what the textbook calls them. We're going to use that as a way of pulling all of that together. Because this, my friends, is week 10. We only have one more week of substantive content, and then we are going to spend all of week 12 doing revision. And revision will be in-class quizzes, activities, those kind of things. Plus, in that week 12, I will walk you through the form of the exam. I will not be telling you what the questions are, but I will be walking you through the form. Now, it's not very hard to find recordings of my lectures from years gone past on YouTube. Be careful because I have changed the form of the exam this year. Not substantially, I think for the better. I have been very worried about how much reading time you have. So OUA get 10 minutes of reading time. Face-to-face get 15 minutes of reading time. I don't know, it's ridiculous, I don't understand either. But the thing that really I don't understand is that you're not allowed to lift up a pen during that 15 minutes or that 10 minutes. So I don't actually understand the function of reading time other than to make you panic. So what I'm really trying to do is find a way to set up the exam so that there is less time spent panicking, more time spent answering questions. So I think the newer format where you've got less problems to focus on, so your mind's not darting all over the place, will help in relation to that. And also, the more you panic, the harder it is for you to write good stuff, and the more boring it is for me and more disheartening it is for me to mark papers. So, and it's all about me. I want it to be awesome. So let's do that. So that's my plan of attack for today. I do have a quiz that I am happy to throw in in between so that we can work out what to focus on, but let's see how much time we've got. So Toll and Alphapharm. So facts of this case are not entirely straightforward or easy to get your head around, particularly given that it seems that every party who has a significant role to play in the facts is not a party to the case. So Alphapharm was the distributor of a flu vaccine. They were actually the sub-distributor to a head distributor, which was EB. So EB basically had the main contract to distribute this flu vaccine, and it appointed sub-distributors to do part of that job for it. Alphapharm had a contract with actually a company called Fine-Moores at the time, but Fine-Moores ultimately became part of the Toll group, which is why Toll is a party. So I'm going to use Toll as the name here. And Alphapharm's job was, Toll's job was to collect, deliver and store these flu vaccines. It was really important that the vaccines were transported in the correct way and maintained at the right temperature. Fine-Moores, or Toll, gave a cover letter with a quote that included saying that services were subject to the conditions on a consignment note. So we end up with two different bits of paper. We've got a letter with a quote that says we'll do all of these things and this is how much it will cost. And the terms and conditions will be on this other piece of paper, this consignment note. So a consignment note is quite a standard language. It's a delivery docket, basically. It's the piece of paper that the transport company asks the sender of goods and the recipient of goods to sign at each end. So when they provided the letter, they didn't actually provide a copy of that consignment note. They just said it'll be subject to our standard terms and conditions on the consignment note. So I guess it was foreseeable that they might change. Then one of EB's representatives went and signed a credit application which included some conditions of contract on the back. So this is a credit application with Fine-Moores. So effectively what EB was saying is, we want to use your services in advance. We need credit to do that. So in other words, you'll do the stuff before we pay for it. And there are terms and conditions that are on the back of that. So we've got now 3 documents: a quote, consignment note, and this credit application form. And all of them together have different terms and conditions, and all of them are prepared by Toll or Fine-Moores. On the conditions of contract that the rep didn't read, there were 2 clauses. One of them said that EB was entering the contract on its own behalf and as an agent for its associates. So that became, one of the questions in the case was it entering into this contract on its own behalf and as an agent for Alphapharm or not? And then clause 6 said that Toll would not be held responsible for the loss or damage of the goods. So we're talking about an arrangement here where Alphapharm is getting Toll to carry these goods around, keep them in a particular way, maintain them at a certain temperature. Alphapharm's doing that under contract to EB. EB has signed a contract with Toll that effectively excludes Toll from liability if they get things wrong. Alphapharm, so basically Toll got it wrong, Fine-Moores got it wrong. They didn't maintain the temperature of the vaccine, so the vaccines were spoiled. So EB then has a problem with Alphapharm because Alphapharm was supposed to maintain this vaccine at the right temperature. Presumably the government department and the hospitals are also got a problem, but that's their problem is with EB. And why does this matter? Who has the problem with who? It's because of the way that the privity laws work, or the privity rule works. So you can only sue the person you have a contract with. So ultimately, as this started, Alphapharm was suing Toll for the damage to the goods. But it's doing so because it's suffering damage, because EB could sue it, and the hospitals, clinics, people who are expecting, and the government who's subsidising this, whoever it is who has a contract with EB could sue them. So we end up with a couple of different issues. So this is a really good illustration of the state of the law of contract generally. So around the question of acceptance. So the big question in this case was whether the conditions that were on the application for credit were part of the contract or not. In particular, that 5 and 6, the exclusion clause and the agency clause. So, firstly, was there an acceptance of this clause? Ultimately, the rule in Lestrange and Grocke applied. It didn't matter that the representative didn't read the contract. Signing it is a way of indicating that he read it and accepted it. Intention and acceptance are measured objectively. So again, this much better case, High Court decision, unanimous High Court decision, no issue, not the same sort of issues that you do with Chong and Fitness First, or Fitness First and Chong. The privity and the agency question. So the question here was, could EB do something that bound Alphapharm? Could EB's representative bind Alphapharm to something that EB's representative hadn't even read? So here the answer to that question was yes. The evidence showed that the representative, and who was a representative of EB and acting as an agent of Alphapharm, was authorised by Alphapharm to enter into the contract and to agree on standard terms. So as long as FindMore's contract was standard terms, as long as these weren't unique terms or something different, they were authorised to do that. So the agency relationship meant that the principal was bound by the agreement. So again, if you remember back to the cases around privity, one of the ways of getting around privity is actually to be really clear that the person who is signing the contract is doing so as an agent for the principal, because that means the principal is a party to the contract. So even though the agent is the one who signed it, the agent is the one who's negotiated, it's the principal who is bound. So a really good example of that is buying real estate. You go to an auction, say you make a successful bid at auction, you'll be in one room of the house and the vendors will be in another room, and the agent will go between the two of you. Now, in some circumstances, you might even have a buyer's agent acting for you. That person might actually be authorised to sign the contract. But they're not doing so on their own behalf, they're doing so as your agent. And so it is you that is bound. If they go outside the terms of their agency, you might have the ability to sue them, but unless that's clear to everybody else, you're still a party to the original contract. So again, thinking about, particularly when you're dealing with agents, think about, well, what are the contracts here? You've got a contract between yourself and the agent appointing you. Again, remember Section 126 of the Instruments Act. Very difficult language, but part of the language there is, if effectively has the impact that if it's a guarantee or it relates to land, it needs to be either an agreement that's signed by the parties, a memorandum or note of agreement that's been signed by the person you want to sue, or that it's been signed by the agent, so the agreement or the memorandum note has been signed by the agent who themselves has been appointed in writing of the person you want to sue. So again, we need that written appointment piece. So what was the effect of the signature? Again, the fact that the document is signed effectively deems the result that the person who has signed has read it. So it's not quite as convoluted as the wording in Lestrange and Graucob, where in Lestrange and Graucob, there's some funny wording there that talks about how you've either read it or you're reckless as to what the contents are. Here it's just saying if you've signed it, you've made a commitment that enables third parties to assume the legal efficacy of the document that you've signed. To undermine that assumption would cause serious mischief. And I don't, even though it seems a little bit harsh at one level, thinking about it, like how would you feel if somebody else could sign a document that they hadn't read and the end result means that you are bound by that contract? That feels unfair. Okay, just calling it for what it is. But if we think about what the ramifications would be if people could sign documents and the defence was, when they didn't want to do something, oh, I didn't read it, we would literally end up with chaos. Serious mischief is, that's judge speak for anarchy. So I'm expecting you to call out if you've got questions, by the way. Then the next question that they dealt with, the final significant question, was the one of whether there was reasonably sufficient notice. So now why is notice important actually? Just see if you were paying attention last week. The timing of signing can affect, the timing of a term.
Like before you sign or
yeah.
How far.
So you're thinking of Van den Eschet and the house, the ants and the termites or whatever it was. Absolutely. So timing is relevant. If you are going to incorporate terms in a contract and those terms are not part of a document that looks and feels like a contract, and an application for credit isn't a contract as such, it's a credit application form. So it might not look like a traditional document. But so if we've got a ticket, for example, or terms and conditions for parking your car in a garage, or terms and conditions for collecting your dry cleaning, the law is pretty consistent. If it's not immediately clear that you're being bound by a contract, you need to give sufficient notice of onerous terms. One of the cases that we didn't talk about last week but is referred to in your textbook, and I've given you the slides, so there are slides there to have a look at, is one called Interphoto and Production, something Productions, British case. In that case, so it's back actually in the 1980s, if you couldn't just go to Google Images and find an image and cut and paste it and put it into your document. So people who wanted to use images, they would have databases of images and they would send you bromides or screenshots that were suitable for adding into printing. And so Photo Productions basically had a huge library of images. And they sent images off to their customer, and inside the envelope where they sent the images, there was sort of a statement, like 15 images on loan to you for however many days, and buried in the middle of the clauses, and it was quite deep into the clauses, was something that effectively said, if you don't return all of these images by a certain time, we're going to charge you X quid a day. And it basically added up. It was about £4,000 by the time these people sent their images back. And they said, well, hang on a minute, we didn't see that clause. And it's a good case for pulling together all of the law around how, well, if it doesn't look like a contract, particularly if it's an onerous clause, you need to bring it to the attention of the parties. So that's why this is in issues here. So in this case, the court said, well, actually, yes, it was an application for credit, but it was pretty clear that it had contractual terms on the back of it. And it was pretty clear that it was being signed by this guy as an agent. So he had enough notice that there were potentially serious ramifications of signing the document. A person who signs a contractual document without reading it is bound by its terms only if the other party has done what's reasonably sufficient to give notice of those terms. This should be given a narrow focus, they said. It only applies for exclusion clauses or unusual clauses. This wasn't anything particularly unexpected. So I think this case pulls together a lot of these concepts. So if you haven't, I know you've read everything, but if you haven't read everything twice, read this one a second time. This is the one to focus on that. Any other questions, concerns, frustrations?